Are you a senior feeling overwhelmed by bills piling up? What if I told you right now that you don't legally owe some of those bills? That's right. Not everything that comes in the mail has to be paid. Stay with me because in the next few minutes, I'm going to reveal the 6 types of bills struggling seniors are often mistaken to owe, but legally don't. Make sure you watch until the very end, because knowing this could save you thousands and protect your financial future. Before we jump in, please hit that like button, share your own bill nightmare in the comments, and subscribe so you never miss vital legal tips designed just for seniors like you. 1. Medical bills not covered by insurance. Let's start with one of the most stressful, unexpected medical bills. Many seniors assume that if a bill arrives in the mail, they're automatically on the hook for it. But that's not always true, especially when it comes to treatments that weren't properly authorized or fully disclosed. Picture this. You're taken to the hospital in an emergency, and days later, you get hit with a massive bill from an out-of-network doctor you never even asked for. That's not just unfair. In many cases, it's illegal. Thanks to recent laws like the No Surprises Act in the U.S., patients are protected from many types of surprise billing, especially for emergency care or services provided at in-network hospitals by out-of-network professionals. Seniors in countries like Australia, Canada, or the UK may also have similar protections or public systems where private billing needs to meet certain standards. Now, even if a bill seems legitimate, insurance companies sometimes deny coverage unfairly due to coding errors, missing referrals, or their own red tape. That doesn't mean the bill is your responsibility. You can appeal the decision, demand itemized bills, and request a review of medical necessity. Providers often include incorrect charges or bill for services never performed. So before paying a single dollar, ask yourself, was this care pre-approved? Was the provider in network? Did I authorize this service? And here's a tip from inside the legal world. If the provider can't prove you agreed to the charges in writing or the charges were misrepresented, you may have a strong case to negotiate down or even dismiss the bill entirely. Always ask for documentation and never assume that medical bills are final. 2. Debts from a relative's account. Many seniors get emotionally blindsided by collection calls or letters tied to a deceased spouse, adult child, or even an estranged relative. The voice on the phone sounds firm, even intimidating. You need to settle this account. But here's the legal truth. You are not automatically responsible for someone else's debt, even if they were family. Let's say your late husband had a credit card in his name only. After he passes, the card company might still try to contact you, not because you owe the money, but because they're hoping you'll pay it voluntarily. And unless you co-sign the debt, you're usually not obligated. Even being listed as an authorized user on someone's account doesn't make you financially liable. In some cases, collectors deliberately blur the lines, using guilt or confusion to pressure seniors into paying what they don't owe. They might send letters addressed to the estate of John Smith, but make it seem like you personally owe the money. Don't fall for that. If the debt is truly owed, it should be resolved through the estate, not from your personal savings. If you're ever contacted about someone else's debt, ask for written proof. Request the original agreement with the debtor's name on it. And if they can't produce it, you have the right to walk away. Never make a payment just to make it go away, because doing so could unintentionally tie you to the debt. 3. Unsecured personal loans with no contract. This one is especially tricky because it often involves people you trust, friends, neighbors, even fellow churchgoers. You may have once borrowed a small amount of money during a hard time, or maybe someone claims you owe them for a favor or informal loan. But if there's no signed agreement and no proof of repayment terms, you may not be legally obligated to pay it back, at least not in court. In legal terms, this is called an unsecured loan without a written contract. And while verbal agreements can hold up in rare cases, they're notoriously hard to prove. The burden falls on the lender, not you, to show that the loan existed, that you agreed to repay it, and under what conditions. Let's say a friend says you borrowed $1,000 2 years ago, but you don't remember any written agreement, just a conversation. Unless they have clear evidence, such as a signed note, bank transfers labeled as a loan, or emails outlining terms, it's their word against yours. And that's not strong enough for a court to enforce. Also, beware of people who disguise gifts or casual help as loans later on. Seniors are often targeted for this kind of manipulation, especially if memory issues are involved. If someone's demanding money from you, and you never signed anything, don't pay out of guilt or pressure. Ask for proof. And if they can't produce it, consider speaking with a legal aid office or senior advocacy group. 4. Utility bills for services you didn't use. Now, this one's more common than people think, especially for seniors who've moved homes, gone into aged care, or temporarily stayed with family. You might receive a gas, water, or electricity bill and feel obligated to pay, even though the service wasn't being used or was disconnected. But here's the truth. You're not responsible for paying utility bills for periods when you didn't receive the service, no matter what the company says. Utility providers make mistakes all the time. They might continue billing after you've officially canceled service. Or they might charge you for a property you no longer own or rent, even months after you moved out. And in some cases, landlords or property managers may try to pass off their unpaid bills to you, hoping you'll cover the cost to avoid hassle. Let me give you a real-world example. A retired couple I advised moved into assisted living, and weeks later received a $600 electricity bill from their old house, even though they had disconnected service before leaving. The provider claimed it was a late adjustment, but upon investigation, it turned out the meter hadn't been properly read. They were being charged for someone else's usage. Seniors, listen closely. If you no longer live at the property, ask for proof of the meter readings, dates of service, and termination confirmation. You are only responsible for your share, not errors made by the provider, the next tenant, or the property owner. If the company can't provide accurate documentation showing you received and used the service during the time billed, you do not legally owe them anything. And if they send the bill to collections, you can dispute the debt in writing and request an investigation. Under consumer protection laws, they cannot continue to pursue payment without verifying the charges. Never pay out of fear or to avoid confrontation. Stand your ground, and if needed, get your local consumer affairs office involved. 5. Old debts beyond the statute of limitations. This one shocks a lot of seniors, especially those who feel ashamed about unresolved bills from years, even decades ago. Debt collectors might suddenly pop up out of nowhere, claiming you owe $2,000 from a store credit card you forgot existed in 1999. And here's where the legal knowledge can truly save you. You may not owe a single cent because the debt is too old to collect. Every state, province, or country has something called a statute of limitations, a legal time limit for creditors to sue you for unpaid debt. Once that time is up, the debt is considered time-barred, which means they cannot take you to court to force payment. In the U.S., for example, that time limit is typically 3 to 6 years, depending on the type of debt and your state. In Australia, it's usually 6 years for most unsecured debts. In the UK, it's also 6 years or 12 years for mortgage shortfalls. But here's the catch. If you make even one small payment on that old debt, or admit that you owe it, you could accidentally restart the clock. That's why it's crucial not to respond emotionally or impulsively. If a collector contacts you about an ancient debt, don't agree to anything until you verify the age of the debt and your legal rights. You have the right to request a validation letter or a proof of debt under laws like the Fair Debt Collection Practices Act, FDCPA. In Australia, similar rights are protected under ASIC and state-based consumer laws. If the collector cannot provide documentation or the debt is too old, you can legally walk away. They might still try to pressure or guilt you, but they can't legally enforce the debt in court. This happens to seniors all the time. Don't fall into the trap. Just because someone says you owe money doesn't make it true, and the law might be on your side more than you think. 6. Bills from scams or fraudulent companies. Finally, and most heartbreakingly, let's talk about scams. Seniors are disproportionately targeted by scammers pretending to be debt collectors, utility providers, tech support, charities, even government agencies. They'll send you bills that look professional, threatening, and urgent, but they're fake, and you don't legally owe a single thing. One of the most common scams I've seen is the phantom bill scam. A senior receives a letter or email saying they owe money for antivirus software, medical alert systems, or home repairs, services they never requested or used. The scammer includes just enough personal detail to make it look real. They may even follow up with a call using a stern voice and legal jargon to pressure payment. Here's what I want every senior to know. Legitimate companies will never demand immediate payment without proper documentation. If you get a bill that seems suspicious, especially if it asks you to pay with gift cards, wire transfers, or prepaid debit cards, it's almost certainly a scam. You have the legal right to demand verification. Tell them to send a written invoice and prove the bill is real. Ask for the company's license number or business registration. Look them up online and search for scam reports. If they refuse to cooperate or start threatening legal action out of the blue, that's a major red flag. Also, don't let shame keep you from taking action. Scammers count on seniors feeling embarrassed, but there's nothing to be ashamed of. Report the fraud to your local consumer protection agency, the FTC, or ScamWatch in Australia. You're not alone, and stopping these people protects others too. In the eyes of the law, if a charge is fraudulent or based on a scam, you are not liable, period. You can and should fight back. And in many cases, you can get help recovering your losses or at least stopping the harassment.